These are part-heard appeals in the matter of Bath Racecourse Company Ltd and Starboard Hotels Ltd and others, and Liberty Mutual Insurance Europe and others.
My lords, I hope you received the end of day transcript yesterday.
Sorry?
I hope you received the end of day transcript yesterday. And I've got hard copies I can hand up if that would be of assistance.
I haven't yet seen it, but my clerk may just not have given it to me yet. It reached me.
Yes. Well, I've got copies if it would help, but just let me know.
Well, I've managed to leave the call bundle in my room. When my clerk comes back, I'll ask him whether he's got it, and we'll see. If not,
I'm grateful. We just finished the New Zealand case yesterday of public trustee, and just so that my lords have my submission on that, we say in that case the court's starting point was that each insured should be construed as being entitled to the full limit.
Speaking for myself, I'm not sure we really get much from that case. It's a first instance decision, albeit the Chief Justice. It's not really got much reasoning. I don't think we're going to decide this case on the basis of...
My lord, I wasn't suggesting that, but it's just to work through the cases that Conway identifies.
Approach, but
With that warning from my lord in mind, I'm going to venture a first instance decision from Hong Kong next. In the New World Harbourview case, which we say adopts a similar analytical structure, and we address that case at paragraph 31, sub 2 of our skeleton. My lord the Chancellor noted yesterday he'd seen this case in the test case. I think that was on appeal.
Yes, I think it was.
This issue was not appealed, so it's the first instance judgment.
It was a SARS case, wasn't it?
That's right. It's in the authorities bundle for this appeal in volume 3. In section B, tab 2.
So which authorities bundle?
The authorities bundle for this appeal. So the insurers' appeals.
Insurers' appeals authorities. Okay, tab 2.
Tab 2 begins on page 1056.
Right.
Sorry, I'm struggling with it's the Insurers' Appeals Authority
Bundle. I've got it in volume 3 of that. And within volume 3, it's section B, tab 2.
Thank you.
And we can see at the foot of page 1056 that the plaintiffs all belong to the New World Group, own or operate convention centres, hotels, etc. And each of the plaintiffs was insured under a composite mercantile policy. And then if we jump through to page 1062, the relevant issue is issue 5, which is set out at paragraph 81. Is each plaintiff entitled to $100,000 in terms of claims preparation costs? And we can then see the clause itself quoted in paragraph 82. And it's not expressed to be on an aggregate basis. The policy is silent as to the basis on which the limit applies. And then at paragraph 83, the court states that the limits issue.
Just a moment. Can you check we've got the transcript from yesterday, please? Is it where? So many bundles. Yeah, okay, thank you. Right, thanks very much. Yeah, sorry.
My lord, I've just taken the court to paragraph 82 in the insuring clause. Doesn't state that the limit's on an aggregate basis. And then at 83, the court states that the limits issue depends on whether the policy is joint or composite. At 84, it makes the point that the policies are expressly described as composite, and then it cites Colombo and the distinction it draws between a single contract in a joint policy and a bundle of contracts in a composite policy. And then at paragraph 85, we can see that all the insureds here have different businesses. So there's hotel, private club, gym and sauna, but they're all at the same location. Unlike those in the Bath appeal or indeed Starboard, where the businesses are carried on at different locations. And then at paragraph 86, one can see that the insurer argues that the fact that they are all at the same location means that the policy can't be composite, it should be treated as a joint policy. And that argument is then rejected at paragraphs 87 through to 89. Even though those claimants were at the same premises on analysis, they will have different insured interests. And so the policy was construed as being composite. And then in the absence of words to the contrary, the conclusion that each claimant had a separate limit follows. And we see that with the answers to the fifth question at paragraph 92. Now, my lord, I fully accept it's a first instance decision of Hong Kong, of the Hong Kong courts, but it's of a piece with public trustees, and Colombo cites it as representing the correct approach to take. It cites that case uncritically. The third case then is Corbin and King. We can put away volume 3 and go to volume 1.
That is in terms of Commonwealth cases?
No, this is the third Colombo case. Colombo cites 3 cases: public trustee, New World Harbourview, and Corbin and King in that passage that I took, my lords.
Is English, isn't it?
That's right. So it's two overseas.
I was asking about, is that it in terms of Commonwealth cases?
Commonwealth. I'm sorry, my lord. I misheard.
Commonwealth cases.
That's it.
So there are there's nothing on any of this in the Australian or New Zealand cases.
Not that we've been able to find beyond the 2 cases that I've referred to.
Okay. Right, Corbin and King.
Corbin and King. It's the first volume at tab 13.
Yeah.
Again, Colombo cites without criticism.
Sorry, page?
It's tab 13, page, begins on page 405.
Yeah.
The disquiet that my learned friend referred to isn't picked up in Colombo, it's cited uncritically. Now, the insurers say that the reasoning in this case goes awry, as my learned friend Mr. Scorer submitted yesterday, but we endorse it and we say it's of a piece with the analysis in the previous 2 cases and indeed New Hampshire. Now, briefly on the background, we see at paragraph 9, which is on page 409, that the insureds were Corbin and King and subsidiaries. And if we turn over the page to 410, the subsidiaries are named.
Yeah.
Each subsidiary owned and ran a different restaurant in a different location in London or elsewhere. And we see at paragraph 10.
I should correct my little friend. One subsidiary ran 3 restaurants. All the other subsidiaries had 1 restaurant. One sees that at a footnote.
Yeah, because the Wolsey's got more than 1 restaurant. Is that the point?
No.
It's not.
One sees a footnote at page paragraph 237. It was important because the composite policy point only got you home in relation to a number of the claimants, but not in relation to the claimant with 3 restaurants. So if I'm sorry to interrupt, but I thought...
Which paragraph of the judgment?
Paragraph 237, there is a footnote. I think it's footnote 5.
Page 451.
Page 451. And what one sees there, a footnote, and you go to the bottom of that page.
The Wolsey Cafe at Bristol Village.
There was one cafe, the cafe was at Bristol Shopping Village. It and the cafe restaurants, the Soutine and the Belen shop, are owned by one company. So the structure actually was that most of the subsidiaries owned 1 restaurant, but 1 subsidiary was involved with 3. I'm sorry, but I thought I should.
But I mean, for just in general terms, it's a composite policy because there's a series of related companies who owned their own separate restaurants.
Exactly.
But
there was this slight quirk.
There
was this quite slight quirk, and
yeah, thanks very much. Yeah, okay.
I'm grateful to my learned friend.
Corbin and King. Then, so we're going to look at what? I mean, we looked at this case in the sense that we know broadly what it's about because it raises all sorts of COVID-related issues.
Yes, my lord. I mean, just briefly, the law on composite policies is set out briefly, and we say accurately
Yes,
at page 428
428.
under the heading composite policies. My learned friend Mr. Kramer's already been through those principles, but one notes the reference to general accident and McGillivray,
Yeah,
the commercial convenience of insuring on a composite basis. And then if we jump to 447,
yeah,
see the heading, the quantum issue, and over the page, paragraph 222, you can see the issue, which is essentially the same as in our case, subject to, I don't know, from Mr. Gruder's point. In essence, subject to that caveat, the footnote 5 caveat, the claimants and the premises in this case were interchangeable. Now, the judge's discussion of the issue begins at paragraph 228, page 449. And just in terms of the architecture of the reasoning, the judge splits the arguments into what she describes as legal arguments and construction arguments. The legal arguments are about whether the policy is composite, properly so called at all. And the construction arguments are then effectively the limits point. And the legal arguments run from paragraph 230 through to 237.
Was she right to describe it as a legal argument, or is it all construction?
I think it's probably ultimately all construction, because one construes the contract and then one characterises it based on
but
the
at
construction.
the end of the day, that bit of it doesn't really matter, because it's common ground here, that these are composite policies.
That's right, my lord, and that actually leads me to 2 points that my learned friend Mr. Scory made yesterday, or in his skeleton argument. The first actually is in paragraph 51.3 of his skeleton argument, where he emphasises, and I think he emphasised on his feet as well, that Mrs. Justice Cockrell says that New Hampshire doesn't take matters much further. That's actually in this bit about whether the policy is composite at all, not the limits point. One sees this at paragraph 235 on page 450.
I'm sorry, it's my fault. What she was describing as the legal argument was not an argument about whether it was a composite policy, was it? She was describing the legal argument as what consequences flow from the fact that it's a composite policy.
Yes, my lord, I think that's probably a more accurate way of putting it. So whether it's a separate bundle of contracts, essentially.
But at the end of the day, I think what we're suggesting is it's really a question of construction.
Throughout.
I mean, this is, you know, in a sense, the point about legal arguments is the same point, isn't it? As, you know, is there an expectation or a presumption? Well, let's say presumption, because expectation could be interpreted in a number of ways.
Yes.
Is there a presumption which is redolent of there being presumptions of fact or presumptions of law? And it may be that ties in with what she's saying here, but you know, speaking for myself, I have a slight difficulty with that, because it seems to me at the end of the day, it's a question of construction of the wording, full stop. You could have a composite policy, and there are, you could have a composite policy which made it clear that the limit, for example, the limit in the Bath Racecourse policy, 2.5 million, was a limit in the aggregate applicable to all claims. It could still be a composite policy in the sense that one insurance insured a whole load of separate insurers with separate premises. So it's not really there's no legal presumption, it's simply a question of construction of the contract. What you can say, which I think is what's said in New Hampshire, is in general, without more, without some clear provision that the limit is an overall aggregate limit. In general, the limit will be the insured's particular limit.
My lord, yes, and I think that's really what the judge is driving
Yeah.
at both paragraph 230 and 238, where she refers to expectation.
No invariable rule, yeah.
Yeah, it's the same as saying in general. Now, that was the focus, of course, of my learned friend's attack yesterday. He calling it an expectation as going too far. And I'd just make 2 brief submissions on that. The first point is that Mrs. Justice Cockrell wasn't treating the expectation as determinative, because if one looks at page 451 and 452, she goes on to consider the wording of the contract and to construe it, and one sees the conclusion at page 452, where she says, overall, the picture which emerges from a consideration of the wording and a consideration of the nature of the policy persuades me without difficulty, etc. And we say that's an entirely unobjectionable conclusion. So the expectation isn't irrebuttable, if I can put it that way. And then secondly, on the meaning of the word expectation, and we've touched on this already, it must be the expectation of the reasonable policyholder, because this is an exercise in construction. And so we say it's just another way of referring to the presumed intentions of the parties. And we say that presumptions do remain important for the construction of insurance contracts. The most famous example, of course, is the presumption that parties intend proximate causation when they introduce words of causal linkage between peril and loss. And if we could briefly go to the common authorities bundle in volume 1.
So this isn't in the insurers?
No, I'm sorry, my lord. I meant to ask at the outset whether my lord had located.
Well, one thing
Common
we
authority.
are going to say, I'll say it now, but so those behind you have an opportunity to start beavering away if they need to, is that for the purposes of the cases we're going to hear next week, we want all the authorities that are going to be relied upon in one series of bundles, not in 3 series of bundles. It's completely ridiculous, putting it bluntly.
My lord, I'm sure that's been heard. If we could,
I had assumed that was the purpose of the joint
Yes,
authorities
so
bundles, but when we got our reading list for next week, there were 6 authorities to which we were referred, of which 2 had a reference in the joint authorities bundles, 1 had a reference in this week's insurers authorities bundles, and 3 had a reference in the furlough appeals bundles.
Which is why we're saying they should all be in one. So we don't have to cart around endless bundles.
my lord,
The other thing, which, since I'm on the topic, is that the bundles for next week, we've got these case-specific bundles, which don't include the policy. So we're going to have to bring, and unless you do what I've done, which is put all the 3 policies we're likely to need into one separate bundle, which is smaller than the others and easier to lift, then we're going to have to bring this week's bundles next week as well, which we're just not prepared to do. So somebody better start thinking about preparation of bundles for next week, please.
my lord, that's understood. I think.
Anyway, sorry, that's really directed at everybody, not at you. Okay, you want to take us to common authorities bundle, which one?
Volume 1, tab 3.
Volume 1.
Volume 1, tab 3.
Yeah,
It's the Supreme Court decision in the FCA test case.
this is the test case.
And within that, page 258.
Mm-hmm.
It's just to make good the submission I made a moment ago about the use of presumed intention as
Yeah.
an aid to construction of insurance contracts. One sees at the top of the page, in paragraph 163, a reference to section 55(1) of the Marine Insurance Act. And then Lords Hamlin and Leggett say that the requirement of proximate causation, this is at C, is based on the presumed intention of the contracting parties. And my Lord Justice Popplewell made a similar point, I think, in the Brian Layton case. That the idea of presumed intention obviously isn't limited to insurance contract law. Outside of the insurance context, a classic example is the Gilbert-Ash rule.
Sorry?
Outside of the insurance context, a classic example of presumed intention is the Gilbert-Ash rule. The idea that parties are presumed not to give away valuable rights unless otherwise. And we do have triple point in the bundle for this appeal, and we could go back there briefly. That's in the insurers' appeal authorities at tab 10. In the first volume.
Yeah. Triple point, yeah.
And if, within that, if we go to page 291, it's the judgment of Lord Leggett, and one sees at D a quote from Viscount Diplock's judgment in the Gilbert Ash case, where he refers to, but in construing such a contract, one starts with the presumption that neither party intends to abandon any remedies, and that's then discussed by Lord Legate from paragraph 109 through to 112, which is on page 293. Citing along the way Andrew Burrows' GC as he then was at paragraph 111, where he talks about the modern approach is recognising that a party is unlikely to have agreed to give up a valuable right. And then at the foot of 112, which is at the top of page 293, Lord Legate draws that together by saying these descriptions well express the doctrine that many types of contracts are regarded as having certainly ordinary incidents derived from the nature of the relationship they create, which inform the interpretation of the contracts and which clear words are required to displace. And in our respectful submission, we say that the reference to Corbin and King to expectation is effectively a reference to that source of legal analysis. It's an ordinary incident of composite policy. We say to have separate limits, but obviously that starting place can be displaced. That starting point can be displaced on a construction of the contract, applying the usual principles.
In this case, we've seen numerous provisions, which I think everybody accepts, provide for aggregate limits. One can possibly say they're clear words. It's just obvious from looking at the contract as a whole. So this presumption doesn't go so far as to require clear words.
Yes, well, I know there's obviously an issue for the court as to if there is a presumption, how sticky is it? If I can put it there, how strong is it? Is it a clear? Does it require clear words or just words properly construed?
Well, that's why it's like Camel at the concept of presumption. You said a moment ago, ordinary incident. Well, that's much more like in general.
Yes.
Or the natural meaning, which I think is one of the judges says in New Hampshire. I can't remember which now. Natural meaning, I think. That's all. That all seems fine because you then look at the contract and you see, for example, as my law says, that the 89 million or whatever it is plainly isn't per insured, although the contract doesn't actually say that. But in relation to the limits that we're concerned with, the 2.5 million in the Bath Racecourse policy, there's nothing that suggests it's an aggregate limit. So you say, well, the ordinary.
The presumption applies.
Being composite policy,
It's not,
each insured has its own limit.
my lord's right. It's not part of our case to say that you require clear words to displace the presumption.
This is in an argument yesterday, Mr. Kramer said, I thought very clearly that he accepted that it either has to be a presumption of law, which this can't be, or a presumption of fact, which this can't be. So he said that pushes one back onto a rule of construction, which these days we don't tend to put much store in. So I thought that was your client's position.
Well, my lord, I think the submissions that I'm seeking to advance are in answer to those exchanges yesterday, which is that one can have a reference to presumed intention when construing insurance contracts. And that would be a way of understanding how the composite policy point feeds into the overall construction of the contract.
But I just wonder if you really need any sort of presumption here, because it always arises from, it seems to me, from the context, and the context which is agreed is that we are construing a series of bilateral contracts which are contained in a single document and therefore are to be construed together. The starting point is we're construing bilateral contracts. So each provision, prima facie, relates to a contract between the insurer and the insured. So it's not a matter of presumption, it's just what you are construing.
Well,
and so that is the starting point. And it's not a presumption, it's just the exercise you're involved in. And so in order to say, well, this provision between an insurer and insured in fact engages an aggregate limit, is departing from the starting point, which is that you're looking at the rights between insurer and insured. But because it's in a composite policy, you can do that quite readily.
My lord, yes.
So it doesn't seem to me that we're talking here about presumptions or anything other than looking at just the exercise you're involved in.
Yeah, I'm just picking up on my lord's point, which is very helpful. That you construe the contract on the basis that, for example, it's a contract between the insurer and or between Liberty Mutual and Bath Racecourse, and the limit is for Bath Racecourse's claim, because that it is a bilateral contract within the composite policy, unless that wording of the policy makes it clear that in fact you introduce into that bilateral contract a broader concept which is applicable to the composite policy as a whole, not just to the individual insurers, but to everybody, which would require some sort of aggregate overall limit that made it clear that it was applicable to everybody in the who's within the insured. That's not a presumption; it's simply construction, isn't it?
Well, it is. It's a starting point for construction.
Yeah.
And just as, for example, when one sees caused by in an insuring clause linking loss and peril, one starting point is to say that's proximate causation, unless it's displaced by something else in the contract. So, in a sense, I don't mind what the label is, so long as the
Well, that's
the analysis is that
the label point is quite a good point. Really. So there was a certain amount of quibbling yesterday as to whether there were separate contracts of insurance or separate insurances, whatever that means. I'm not sure what it does mean, really. I mean, clearly, they are separate insurances, and if they're separate insurances, then they're separate contracts, which is, after all, what the insurers admitted below and what they actually say in their own notice of appeal.
yes, my lord. I mean,
On this point, they actually say that they're separate contracts of insurance in
Yes.
ground through their notice of appeal.
Perhaps another way of looking at it is to take account as context the nature of the term with which we're concerned. That is to say, the nature of a limit. And a limit is a cap on the amount that a particular claimant can claim in relation to the claim that that claimant is putting forward. Now, if that is the nature of the term in a composite policy of the type that we're concerned with here, and constat all composite policies, but in a property or business insurance composite policy of different assureds with their own property and their own separate businesses, then the nature of the term, that is one which limits an individual's claim, might lead one to take as the context that the limit applies to that person's claim in relation to that person's interest.
my lord, I don't resist that way of looking at it, but in my respectful submission, it's helpful to have a starting point, whether you call it a presumption or you say it's X and less Y, or whatever it may be. That's clear, provides parties with some certainty.
Well, it may be, but that, all of these Supreme Court authority tells us that you don't have a starting point. It's an iterative process. Ultimately you're interpreting the language, but the commercial context, factual matrix, whatever you like to call it, is important, and it's an iterative process, and it doesn't matter where you start, but you have to take into account both.
Yeah.
I've been told by Mr. Kramer that he may come back to the point, but
Right.
so duly nudged by my leader, I'll move on.
Yes. Okay.
I was briefly then going to address Stangate and Technip.
Yeah,
I can take these cases briefly. Stangate, I'm afraid, is again in the joint authorities bundle at tab 4.
Yeah.
Now, the limits issue in this case was concerned with occurrence-based aggregation. Stangate was a holding company whose subsidiaries operated various pubs around the country, but the insurance was not at operating company level, it was at holding company level, and it was the sole insured, and one sees that on page 313, paragraph 11. And again at page 331, paragraph 102. Where the judge refers to a master location schedule. Now, the insured in that case argued that occurrence-based aggregation principles meant that nonetheless, despite Stangate being the only insured and it not being a composite policy, the limit should apply per premises, and the judge rejected that. I just wanted to draw attention to one of the reasons why he rejected that, and that's over the page at 332. Paragraph 108, where the judge says there was only one insured under the policy, namely Stangate, and not any of its subsidiaries. The policy was not a composite one, whereby separate insured locations owned or operated by separate insured entities had in effect its own insurance. Now, it may follow on that logic, it's always dangerous to do a hypothetical with a case, that had the policy in Stangate been composite, then each operating company named within that composite policy would have had a per claimant limit, or would likely have had a per claimant limit. So it's not a major point, but it's a sign of the type of reasoning that may be taken into account. And then that leaves me with Technip itself, which obviously my lords have heard a good deal about already. I just wanted to add one point on the wording in Technip, if I may. Technip is in volume 2 of the authorities bundle for this appeal. And within that, if we could go to page 706.
So which volume?
Sorry, it's volume 2 of the authorities for this appeal. So the Insurer Appeals Authorities Bundle 2.
So forgive me, if these are the authorities for this appeal, what are the joint common authorities?
There are authorities that are cited both in this appeal and next week's appeal. So for example, we obviously got this wrong, but we were concerned not to provide my lords with 2 copies of the test case, 2 copies of Marrickville and so on, but obviously we've caused confusion by seeking to deduplicate.
Given that the appeals were always going to be heard by the same constitution, albeit with a few days in between, because originally there wouldn't have been a few days in between because there was going to be 4 days on the insurers' appeals. This is a completely nonsensical way of proceeding in that respect. Whose ever idea it was, because it just means that we're in confusion. Every time we're looking for something, we have to look in for a whole series of different bundles. But anyway, there we are. So which tab?
We're in tab 19, page 706.
706. Right.
And the you see a title 2/3 of the way down the page, scope of insurance, and the judge then sets out scope of insurance, and then at the top of page 707 it says the policy shall be deemed to be a separate insurance in respect of each principal insured hereunder without increasing underwriters' limits of liability. Now there's no similar wording in our cases, and we say that readily makes this case distinguishable, because in that case there was not only an express designation that the policy was in effect composite, but then a caveat that that should not increase the number of limits available. And those words, without increasing underwriters' limits of liability, are obviously striking. Now, obviously, that case wasn't about limits, but it's just to give the court an example of how insurers, if they want to avoid the multiplication effect of insuring on a composite policy, they can readily.
It's an overall limit applicable to everybody.
My lord, yes, they can, they should, and they do include wording of that type. If the intention is not to result in the sort of analysis that we respectfully submit as the correct analysis on this appeal. My lord, that was everything I wanted to say on Technip. Unless I could be of any further assistance, I'll pass the baton back to Mr. Kramer.
Thank you very much, Mr. Kelly.
Thank you, my lords. I'm going to briefly deal with the composite point to finish off, which I think we should probably call the per-insured point, and then I'll deal with the amendment issue, which also won't take too long. My lord, all I have on the per-insured point is one small point and then a summary of our position. The small point is merely to show you something in the policy that I hadn't shown you before. It's in the Bath bundle, tab 7. It's something I referred to but then never showed you. You'll recall that there's the estimates at page 57, which are the large total declared values estimates. And then I think I failed to show you at page 108 sorry, that's the sorry, 108. The very top, you see the limit of liability. That's items A and B. B is business interruption. And you'll see that there's an overall limit of, and this goes to a point that I think my Lord Justice Phillips made, which is I was talking about limits and he was saying, well, they're only estimates, and obviously he was quite right about that, and I hadn't got this clause at my fingertips. But this turns the estimates into limits if you multiply them by 133%, so to allow for growth in cost and revenue. And it says the specification, it says nor in the whole 133%, which sounds like it's making it an aggregate limit. It doesn't much matter because I completely agree that it's obviously an aggregate limit anyway, but I thought it was important to draw your attention to this.
Obviously from the wording of the policy, or obviously from what you've told us about the actual matrix in which the figures were produced?
Well, obviously, certainly from the factual matrix, but also, in fact, the wording of the policy includes a certain number that are 12 months, a certain number that are 24 months, and 36 months. And we know from the policy there's a number of insureds. So it rather follows, but my lord is right. You really have to know that there's a number of claimants that they put figures in to really get there.
I don't understand that. I quite understand you say you really understand.
Yeah.
Be at page 57. If you are told that you've got 3 items which might appear to apply to the same thing,
Yes.
but the factual matrix tells you that one is for racecourses or whatever it may be. So far, so good. Then
Yes.
you've just got 3 separate
Yes.
items.
Yes.
That doesn't tell you whether.
No. I think I'm being unclear.
Racecourses, for example.
What I'm saying, that's right. What I'm saying is that the very fact of the 12 months and 24 months rather points you up that you need to go to some factual matrix. So it's almost incorporated by reference in that there's a gap. Someone has to interpret 12 months and say, well, what's 12 months? What's 24 months? I don't think it matters because I don't think anyone disputes that the agreed and assumed facts are admissible factual
Well, the
matrix.
current dispute isn't about the estimated gross revenue
No.
anyway.
No.
But I mean, all you need for present purposes is that by one route or another, whether it involves some factual matrix, the figures on page 57 are aggregate limits for everybody, not individual insurers.
Yes, and it's obviously relevant to my lords because my lords see that as a limit that's aggregate and therefore have to factor that into any composite presumption, etc. that we arrive at. My lord, that turns me just to a summary of our position on this per-insured issue. We say that the ordinary policyholder with their own contract of insurance which therefore means their own obligation owed by the insurer to indemnify them alone for their loss alone is expecting limits to be applicable to its own insurance and its insured interest alone. Now obviously there's a question as to what expecting means and where we go with that, which you've just had a discussion with Mr. Day, and I wasn't pulling him back because he was misspeaking, just because I was worried about time. And we do say that's a presumed intention, and we don't think that's an alarming thing. It's presumed only in the sense that it's normal, and you presume what is normal unless the facts point otherwise. And that's true of it's inherently unlikely that people commit fraud. People do commit fraud, but it's inherently unlikely because it's not common. It's less common than other things.
So that presumed intention would apply to the figures at page 57?
It would apply to all figures, yes. And then we look further and we see that it's obviously not the case for those figures. The presumption is rebutted, as it is with the fraudster who's proven to have committed fraud. And it's not necessarily, it's just the way one approaches, and I think that's all an expectation or an ordinary or a normal can mean. And it's the same as, I think, the Gilbert Ash is quite a good example. Parties don't normally give up their legal rights, except when they do. So I'm not going to go so far as to say one needs clear words, but it's just starting from the position of, and I think this may be misworded, but it's a synthesis of what my Lord Justice Phillips and my Lord Justice Popplewell were saying, which is that when one has one's own insurance, it may be best phrased as people don't normally agree limits that are eroded by someone else who's not insured, which is essentially the point. But I do think you need to go beyond merely saying, well, it is context that one has one's own policy, because you need a valence, you need a direction that takes you. Otherwise, you're not, all you're identifying is context, rather than the context usually points in a certain way.
Yeah.
So beyond that, maybe we're at terminology and semantics. But we call it a presumed intention, but my lawyers will have to decide what they think about that. But we think it's because it's commonsensical for various reasons. And we think that brokers would know that, or solicitors whose advice is reasonably available would know that. And they would know it's consistent with the run of authorities. And that's one reason we show you even first instance decisions of foreign courts, although we also have Corbin and King in New Hampshire. None of them say that the composite nature is irrelevant, nor do they say it's neutral. They all step from that to a conclusion, not without construction, but to a conclusion in all cases that the limit is separate, save where in those cases there was express words. Now, I'm not saying that that means there's a rule that one has to have clear words to rebut the presumption, but this is what the reasonable reader has access to, a body of authority that only goes in one direction. Now, the circumstances may support this further, and they do in our case, where the businesses are separate, where they're separate companies managed separately, where they're at separate locations, where they have separate accounts presented separately during the broke, and where the peril affects the businesses separately. I think my Lord Chancellor described this as individual insured specific elements of the cover when we were looking at how it's got to be near your premises and your business is interrupted, etc.
Yeah.
So in those cases, why are they relevant? Well, because separate limits are more commercially practicable, because one's cover is not thwarted or negated by the fact that another independent business has already claimed, which makes it more likely that you intended the limit to be solely for yourself, you're insured. And we say our case has all of those features. So when one conducts the construction exercise, the presumption is confirmed, supported, and becomes the conclusion. And we say that that's actually pretty commercially obvious. We've spent a long time on this because we're in the Court of Appeal and we're testing a new point. But it's commercially obvious from the fact that you're a separate insured, which may be why the reasoning in some of these cases is brief. They're nevertheless, we say, right and should be approved to the extent that that's appropriate, and that they support our case on what the reasonable policyholder would understand, because those reasonable judges came to that conclusion too. And we also agree that conversely, where there's a limit that's built up from separate declared values, or perhaps for other reasons of context where some of those additional factors above aren't present, then a limit may well be intended to be aggregate, and it may not require express language, and we'd be perfectly content to say that, and that the presumption is rebutted there, and that's the conclusion. I don't think there's any difficulty or anything to be alarmed about in talking about presumptions or inherent likelihoods or normalities or expectations, but that's our case, my lord, and if you're happy for me to rest there, I'm going to move to the amendment point, which is relatively... Yes, ma'am.
Let's agree one point.
Yeah.
I think the way it's being suggested is that you're doing an exercise of construction in which the context for construing is that these are 20 separate policies. But I suggest that's wrong. It's the wrong way round. What you are doing, at least theoretically, is you are construing 20 different contracts. And you are engaged in construing each one of those contracts. But the context of construing each individual contract is that they are in one document. So in fact, it's exactly the other way around. You're construing a single contract and a single contract and a single contract, but the context is that they must be looked at together.
I don't disagree with any of that, I was trying by my reformulation of saying, well, maybe the presumption is that one normally doesn't agree limits that are eroded by people who are not insured in one's own policy, one's own contract, to make a general point, which therefore applies when you have a composite policy, and it applies when you have a single policy contract that's not a composite policy, and it's therefore merely follows that just because you're in a composite policy, that generality still applies. And when I'm construing my own contract, normally I'm not going to have a limit that some other insured can erode. Even though it's obviously more likely that I'm going to agree that if they're all in my composite policy than if they're complete strangers to my house policy, because they're closer than the complete stranger. But I don't think we disagree, my lord. I agree entirely with that, and that is the right analysis. My lord, on the amendment, that's ground 4, and you've got the policy. It's the contest between, well, the interaction between page 110, which is the original clause, denial of access, with its 4 provisos, and then page 64, which is the condition 22. Now, we, like the insurers, note that here the parties in the amendment at condition 22, they didn't specify that the limit was to stay any one loss, nor did they specify that it was to become an aggregate limit, otherwise we wouldn't be here, of course. So the question is whether, given that silence, the reasonable reader would understand that the any one loss aggregation basis had stayed any one loss, or that it had changed to the insurer say, and in the aggregate or in the period. Now, I think it must be relevant that, as my lord the Chancellor said, this is not the best drafted policy, and even condition 22, the first sentence is grammatically incomplete because it rather needs an in at the end before the colon. It says the limit, and then in respect of section 2, and it just says proviso. It doesn't say in the proviso or in relation to the proviso or anything like that. That doesn't point in any direction other than one can't parse it too carefully and credit the drafters with perfection. But we say nevertheless, the correct analysis is that the reasonable reader would understand that it not being highlighted that any basis has been changed, the basis remains the same, and all that's changed for proviso 2 is the figure to 2.5 million and the addition of a maximum indemnity period. Now, just going through the particular points that Mr. Walsh made, although not in quite the same order. His first point was that this condition includes the wording notwithstanding anything contained herein to the contrary. And it's true, this appears not to have been used in other conditions, but it simply can't bear the meaning that the insurers say. You can't get that out of the words. It can't mean these provisos replace the earlier provisos, because it just doesn't say that. And it's rather a circular argument, because it's only, the basis of loss is only to the contrary of the earlier basis of loss, aggregation basis, if one reads that 1 million is deliberately intended to exclude any one loss. So it doesn't really add anything, because we have to decide to what extent any one loss is retained.
Well, that's right, because if the herein is a reference to the policy.
Yes, exactly.
All that's changed is the
What's
limit
changed.
and the addition of the maximum indemnity period. It simply doesn't. So that's the contrary. There's nothing else. There's nothing there that says that it knocks out any one loss.
Well, that's right. We say that, and it might be useful to have the judgment open, because I'm going to refer briefly as we go to where the judge deals with these reasons. So that's in the core bundle. These appeals, and it's at tab 1, page 78. Page 77, sorry. Paragraph 370.
Yeah.
I just asked my lord to briefly read that paragraph.
Yeah. That's the same point.
That's the same point. My lord, and the wording, to state the obvious, says amended, and we'll come back to what else it could say. It just says amended, and therefore we say the natural reading is that it's just highlighting the particular things that are amended, and it obviously doesn't highlight a basis of loss. It just says 1 million. And so it's just, well, it's just identifying the particular things that the reader needs to cross-check. I'll come back to the surplusage point in a moment. I'm not going to address, because we say you can't get assistance from looking at the particular amounts and saying, well, these are large amounts and the parties probably intended to make them smaller amounts, and some things are under 100,000 and some things are under 1 million, largely for the point that the tribunal made, which is that the original standard wording included 1 million any one loss. And so we say that Mr. Walsh's fourth point doesn't work and wouldn't inform the reasonable policyholder. We do say looking at some alternative phrasing is useful. Whilst the reasonable reader isn't a pedantic lawyer, we say they nevertheless will compare, because these conditions, one must remember, they're all in a single schedule. They're not endorsements that are engaged in at separate dates, where one could expect variation in wording and wouldn't necessarily be looking at others. This is all agreed on one date in the schedule, and the reader would note that in condition 20 on the previous page,
Deleted and replaced.
Deleted and replaced, which is the way to delete and replace. And the reader would think, well, if I'm unsure as to whether these provisos are supposed to replace the earlier provisos in toto, well, there's a much clearer way of doing that, and the writer's obviously aware of that, and the judge deals with this point at 368.
Yeah.
And we accept that some of the conditions do not specify an aggregation basis, and sometimes they do repeat the aggregation basis.
Yeah.
But we think it's more important to the reasonable reader would think it more important to consider that when one's moving from one basis to another basis, that would have to be deliberate, because this is an amendment. So if you're deliberately moving from one basis to another, which is what the insurers are positing, the reasonable reader is not going to think that in that situation you will fail to specify your new basis. And there are other conditions that change from one basis to another that do specify the two bases. The judge referred to that at 3.8, can't be 389, must be 369, yes.
Yeah.
And I won't look at those conditions, but I will look at condition 8. Which is the wrong condition. No, that's right.
Yeah.
Have I got the right condition? That's each and every. Sorry, condition 7.
Condition 7, which is
Yeah.
the burning,
Yeah.
the greens.
The greens, yes, the old greens, and that's in the aggregate. So, of course, the wording is not entirely consistent across the drafting here, but we say the reasonable reader is going to think, well, if the agreement is to deliberately vary the basis, we're likely to specify the basis. The insurer's case is that it means in the aggregate, and if that were intended, there would have been a specification in the aggregate, and I can see that wording is used in other conditions.
Yeah.
And so the best explanation is the one given by the judge. And as to the surplusage point, which is, we say, the only real construction point that the insurers have, which is, well, if that's right, why does Proviso 1 mention 1 million? Because that figure remains unchanged. Yeah. And we say what the judge says at 371, which is, well, surplusages of minimal strength, especially in a poorly drafted contract. And we refer to triple point, which talks about that at paragraph 119 in our skeleton at 40. I'm not going to go there now. But equally, it makes sense that the parties are thinking, well, the number's obviously important. I'm changing the number in Proviso 2 and 3. I better just restate that it's 1 million for Proviso 1. And also, it might not be entirely clear what I mean if I just say Proviso 1 is amended to a maximum indemnity period of 3 months. There is no indemnity period in Proviso 1 previously. So it just makes the sentence work better to say, well, I'm keeping my 1 million in contrast with Provisos 2 and 3, but I am adding a maximum indemnity period, as with Provisos 2 and 3. Now, it's not the perfect drafting that anyone would recommend, my lord, but we say that that's the reasonable construction and that's where one ends up. There is a subsidiary question, if we were wrong, about what does it mean to have a limit without specifying anything, i.e. just saying 1 million if it's not any one loss. We say that's not a question for today. The judgment records our case at 363 brackets 4, which is that actually it would, if we were wrong, then it would, the default position would be any one occurrence. But I don't want to or need to address that now, because ground 4, which is what we're dealing with, is merely the question about whether the words any one loss have been deleted or not. And there's a separate question not addressed or ruled on by the judge as to if they are deleted, what do you end up with? And my learned friends say, well, it's just the aggregate, but we say that's not necessarily the case.
Yeah.
But the question for us is, do those words any one loss survive condition 22? And we say, for those reasons, that they do. My lord, unless there's anything else, there's Mr. Gruder to come for a little while on the per-insured on Starboard, and then we've got Mr. Scory and Mr. Walsh's reply.
Yes, of course.
Lords, you've obviously seen the authorities. I'm not going to take you again to the authorities. I'll take those as read. But obviously obviously, the Starboard policy, everyone accepts was a composite policy, which effectively means there was one document with a separate contract with each of the companies who were insured. I think is effectively common ground. And I don't think one, with greatest respect, it's not necessary to go down the question of whether there's a presumption or not. The fact is that when you approach the question of construction, which is, in this case, the question of the limit, the framework in which you approach that question of construction is that this is a composite policy and effectively one document but with 20 separate contracts. And that's the framework in which you approach the matter of construction. It's the point of departure or the point of arrival, if one puts it that way. Now, in many cases, perhaps most cases, that may lead to a conclusion that a limit is a limit per company. And we say in relation to the particular prevention of access non-damage cover, which I will come to, because it's a question of construing that wording, it does lead to a conclusion that the limit is a limit per insured, per company. But in some cases, and I think everyone accepts that the main cover relating to business interruption arising from damage, which again we'll come to, that is a shared limit. As in Corbin and King, the similar limit, which was what was called the Great Britain Floater, GBF, was also a shared limit. So it is, I would accept and submit, a question of construction, but a question of construction, not in the abstract, but from a starting point. And if one...
But a question of construction of what? Lord Justice Phillips suggested a moment ago, is that one is not construing the policy as a document. Once the starting point is you are construing each contract within the policy.
Separate contract.
So it's an exercise of construction of a contract.
Of a contract.
Of
Or
which there are a
20
number.
separate contracts.
Not an exercise in construction of the policy as such,
Yes.
albeit that in the policy you find the term which applies to each individual contract. You accept that analysis, do you?
What one can't forget and must never forget, you are construing a separate contract relating to this particular insured, or in this case, 20 separate contracts which apply to the 20 separate insureds who are insured under the Starboard contract. And one has seen, and I don't need to take you to it, but of course the insured was Starboard and associated companies. That's page 52 of the Starboard bundle. On page 53 of the Starboard bundle, it might be worthwhile just reminding my lords that the schedule set out all the different premises, all the different hotels, which were 1 to 20, which were the different insureds were in fact interested in. One then had at page 65 of this bundle the terms of the cover, and you will see towards the bottom of page 65 endorsements applying to all sections, and the first endorsement is named insured, and that endorsement is at page 138 of the bundle, which one then sees the named insured, and then there are numerous insureds named.
Yeah.
And then one sees the previous page, additional named insured. So the structure is quite clear that there are named insureds and premises in respect of which particular named insurers were in fact interested. And one obviously then looks at, because we are concerned with business interruption in this case, we go to page 56 of this document, and one sees the business interruption sections, and then one has, first of all, the gross revenue, and that is based on declared values, 67,451,597, and that we accept is the declared values from all the different hotels, all the different insurers. And then one sees at the bottom total business interruption, 79 million. And of course, there is no potential injustice for the limit, for example, for gross revenue, the limit of indemnity of 89.9 million being a shared limit, because that limit is made up of figures of gross revenue from all the companies. It's not as if you've got some arbitrary limit which one sees in the extensions, that if the insurer's argument is correct, the loss of one insured can effectively consume the whole limit. Here, this limit of gross revenue of 89 million is made up of the building blocks. The building blocks of that figure are the declared values from each of the different companies. That's the difference. That's why one can see it is a shared limit, and it makes sense that it is a shared limit. One then comes to the various extensions, and one sees these extensions are effectively arbitrary limits. They are figures. They're not based on anything. They are figures, and one comes to item 15, which is prevention of access non-damage, 1 million, and it's a three-month indemnity period. And then one goes, and we've looked at this before, but it is worth looking again, to the particular cover, which is at page 140 of this, prevention of access non-damage. And when one construes this as a term, as a cover within a particular contract, because that's the context in which you're engaging in this exercise of construction. And it says, under business interruption, following interference with the business carried on by the insured. But within the context of a particular insurance contract, you are talking about the particular insurers in consequence of action by the police or other statutory authority following danger or disturbance within 1 mile of the premises. It's within 1 mile of the particular insured's premises. Obviously, this does not work. It's a nonsense if you're talking
Well, you
about...
couldn't be having interference with the business of the insured if we were talking about somebody else's premises.
Somebody else's premises. It only makes sense in this context, which shall prevent or hinder use of the premises or access thereto or interference with the business carried on by the insured, i.e. the particular insured in whose contract this cover is found, provided the company shall not be liable under this extension for more than the amount shown against the extension in the schedule, provided the company shall not be liable for more than 1 million to this particular insured. And the judge found, and I obviously have to loyally accept this, that it's a 1 million per-occurrence limit. It's within the context of a particular contract. So in fact, there were 20 separate contracts. There were 20 separate insurers who were interested in hotels under this policy. And this term appears in 20 contracts and has to be construed in that context. And in fact, the danger which was COVID within 1 mile of the premise, that was the relevant danger. The relevant danger was actually different in each case because, of course, the case of COVID within 1 mile of hotel number 1 was a different danger from the COVID which was within 1 mile of hotel number 2, and so on and so forth.
But if you look at it in terms of we're talking about one of the hotels covered, I think is the Ibis Hotel in Leicester. If you remember, Leicester was one of the hotspots for COVID,
Yes.
where there were huge numbers of cases. So you say, well, the danger was clearly a much more extreme danger within 1 mile of the Ibis in Leicester, in all probability, than it was within 1 mile of some hotel, say in Falmouth. I don't actually cover a
I
hotel
don't know
in
whether
Falmouth,
they
but-
have a hotel.
but you know,
in
you know, somewhere,
But the point is well made.
Yeah.
The point is well made. And of course, all these dangers, in a sense, if one applies the Supreme Court reasoning on causation, all these cases of COVID combine together. But the important point is that the case of COVID within 1 mile of the hotel in Leicester was insured. All the other cases outside the 1 mile were not insured, but they were not excluded. But the relevant danger was within 1 mile of a particular hotel in which a particular company was in fact interested. So,
Yeah.
and we say that of course, it would not make in any sense for this to be a shared limit, because with a 1 million limit, if it was shared, as the insurers seek to contend, it's quite conceivable that the first claim or the first and second claim would completely erode the limit for the other 19 or 20 insurers. It's different, we say, from the gross revenue limit, where that limit is made up of figures from all the insurers. So we say that we are right, both as a matter of construction, but also as a matter of commercial common sense. And so we say here, each insured had a different premises, a different business. This was not a policy where there were multiple unidentified or unascertainable insureds who were insured under a composite policy. They were all named, their addresses were set out, it was all very transparent. Each insured owned or was interested in its own hotel or premises, and was insured in respect of its business being operated from the particular premises in which it was interested. So, and of course, each insured did not have any interest in the hotel operated by any other companies from other premises in which it had no interest. And we say if the intention had been to provide for one limit to be shared by all insured, rather than one separate limit for each insured, one would have expected that to be set out clearly, because that is not what one would expect when construing this particular provision at page 140 within the framework of a composite policy. And one would have expected that if one had this, if this was the intention, there would be some provisions as to dealing with competing claims, or which claims would have priority and so on. But of course, the policy contains nothing of that sort. And we say that the cover
So you'd
under
expect
the,
a reinstatement provision, wouldn't you?
yes, some kind of reinstatement provision, yes. We say the cover under the POAND Clause, the Prevention of Access Clause, provided to each of the staff or each of the companies insured under the Starboard policy was for business interruption losses caused by the prevention or hindrance of access to the particular hotel owned or operated by that particular Starboard claimant, and not in respect of business interruption losses at other hotels owned by other companies who were insured under other contracts. And we say the cover was dependent on the proof of a danger within 1 mile of the premises. And obviously the premises were in different places, the 1 mile radii were different, and the insured dangers were different. This really this submission echoes what Mrs. Justice Cockrell decided in Corbin and King. She found that persuasive. And of course, so we say that each insured company under the Starboard policy is entitled to recover the business interruption losses resulting from the prevention or hindrance of access to the hotel it owned or operated, and the interference to its own business up to the limit of £1 million per occurrence. And we say that the insurers' contention is effectively contrary to the proper construction of the extension at page 140. And they don't identify any policy language in their skeleton arguments or indeed in their oral submissions in support of their commercially surprising proposition. And we say that obviously the fact that the Starboard policy is in fact a composite policy containing separate contracts of insurance is relevant to how the limits fall to be construed. We say, again, I make my framework point. And in my respectful submission, the judge actually got it right at paragraph 278, which one finds that at the joint core bundle at page 59. Where he says that he doesn't consider there's any material distinction in the wordings, should lead the court to reach a different conclusion to that reached by Mrs. Justice Cockrell. The endorsement present case refers to this interruption loss following interference with the business carried out by the insured in consequence of action following danger or disturbance of minor premises shall prevent or hinder the use of the premise. Just as in Corbin and King, each of the premises owned by each of the Starboard claimants is in a different location or will be differently affected by danger triggering other context of a composite policy covering the separate interests of each named insured. The limit in the POAND endorsement is sensibly to consider applying separately to each named insured. I accept, as did Mr. Gruder, that it would be possible for a composite policy to provide for what it would be called a shared limit. However, I see nothing in the language of the policy or its context which points in that direction. On the contrary, I consider a reasonable policyholder, knowing that each hotel was owned by a separately named insured, would conclude that the £1 million limit applied to each insured irrespective of an interference might affect that insured, and not understand it as creating a shared limit. In my respect submission, that's right. and various analogies were given by the insurers in their skeleton argument about hull and machinery and D&O policies. I don't think it's necessary, with due respect, to go into that. This is a very simple, I could almost call this a bread and butter policy. It's effectively a business package which provides cover to these 20 companies for various risks that insurers normally supply to businesses, whether it's for property damage, business interruption, money, and so on, liable in some cases. It's a very standard package which was provided in one document to 20 separate insured companies. And then I should also come just very briefly to the allegation, which I think has probably been sufficiently quashed by Mr. Kramer, that there's some alleged disquiet in the insurance market about this case. First of all, I do disagree with Mr. Kramer when he said this morning, this is a new point. It isn't a new point. As one sees from the authorities that have been put before the court, the whole question of composite policies really goes back as far back, if not before, to Samuel and Duma. And then you've got General Accident, and then you've got New Hampshire, and then you've got the Commonwealth cases and Corbin and King. This is not a new point, and therefore there is not a shred of evidence of this disquiet in the insurance market. And I would respectfully say that only underwriters who are unaware of what they are writing and ignorant of the law could actually be surprised of the conclusion in this case. I should turn just to something which Mr.
Well, if you end up writing something which imposes a huge number of losses on you as a matter of the construction of the contracts you've written, then you can understand the individual underwriters might very well be suffering from disquiet. But it's a so what point. It's completely irrelevant. Nothing to do with what we have to decide.
And there was a point which Mr. Scory made in relation to page 81. He made it orally of the Starboard. Sorry, it's it's page. Yeah, it's page 81.
It's an insuring clause.
The insuring clause, and which is section 2. Well, what one sees of course, the insuring clause deals with business interruption losses arising from damage to property in the event that any building, etc. Then it says the liability of the company under this section shall not exceed the aggregate limit of indemnity as stated in the schedule. Now, the first point is it only relates to business interruption arising from the damage to property, damage to buildings. And the second point is the liability of this, even if that's wrong, which it isn't, the liability of this company shall not, under this section, shall not exceed the aggregate limit of indemnity as stated in the schedule. Well, what is the aggregate limit of indemnity? One finds that at page 56. And the aggregate limit of indemnity for business interruption is, in my respective submission, the figure of 106 million, because it's the total business interruption figure of 196.634 million. Well, even if that did apply to this claim, we accept that each insured, each company, under the prevention of access non-damage endorsement is only entitled to claim 1 million per occurrence. Well, with all due respect, we aren't with 20 insurers going to get anywhere near 106.634 million. Also, you should just be. I should briefly show you paragraph 240.
That rather depends how many occurrences there are, doesn't it?
Well, that does depend on how many occurrences there are. Realistically, our claim, we are not. Unfortunately, the occurrences are the various different regulations, and there are unlikely to be, even between 20 insurers, anything more, certainly not going to be more than about 5 occurrences.
I was going to say 4 or 5, isn't it?
Yeah.
4 or 5 separate sets of regulation.
Yeah, because you see, one has got a policy which here when
Well, that would get
unfortunately
that would get you to about 100 million. Actually.
well, but the policy of insurance, unfortunately for my clients, was from the 1st of July to the 30th of June 2020, which only actually
So
leaves
it's not
one.
it's not actually all the occurrences, is it? Would it be? There was a 3-year provision. Was the policy automatically renewed, or?
I don't think it certainly wasn't automatically renewed on these terms, because we are only looking at the policy from the 1st of July 2019 to the 30th of June 2020, and actually there are we are dealing effectively here with the first lockdown, realistically. Now, there are questions about whether, we needn't go into it, but there may be questions about whether there were 2 separate occurrences.
Well, it's a question about whether, because there were 2 separate sets of regulations, the 21st of March.
Exactly, the
26th
21st of March, in relation to hotels, the 21st of March regulation closed down the cafes, the restaurants, the bars in the hotels,
Yeah.
did not affect the accommodation aspect
No,
of the
except people
hotel.
had to eat in their
The
rooms.
the 26th
Did.
affect effectively severely restricted the
Well, it meant
people.
only certain categories of persons, which were sort of
Precisely.
I
Precisely.
forgot what they were described now as, but people like emergency workers
Precisely.
who had to be away from home could
Precisely.
actually stay in the
Precisely.
hotels.
So there were, it severely limited the people who could.
So you can see there. I mean, we're not dealing with this. You can see that you might say there were 2 occurrences.
Correct. But
After that, I think I'm right in saying there were no further.
there was nothing
next-
further
The
because.
next lockdown wasn't until September. I can't remember.
Actually, this lockdown finished on the 4th of July.
4th of July. Yeah.
Then there may be questions in other cases about social distancing, or
Yeah,
in September the rule of 6. But one needn't go into that because this policy expired on the 30th of June. So effectively,
Yeah.
my clients would be delighted
Yes.
to have a claim which got near to the 106 million. But I think it's, I
Extremely
think one
unlikely.
has to be frank to say it's extremely unlikely. And the only other point I should show you is that Mr. At trial, at the hearing of the preliminary issue,
Yeah.
Mr. Scory argued that this limit, if I can put it that way, was a annual aggregate limit. The judge rejected that, and there is no appeal on that. But the judge dealt with the application of that wording in section 2 at paragraph 240 of his judgment, which one finds at
Page 53.
Yep. And what he says there, well, one starts at 239. The insurers seek to reach their conclusion relying on the rest of aggregate limit of indemnity in the insuring clause that begins section 2, business interruption. This refers to liberty mutual liability not exceeding the aggregate limit of indemnity as stated in the schedule. The relevant limit of indemnity remaining after deduction or any other interruption or interference. I do not, however, consider these provision insuring clause can be readily applied to the POAND extension or indeed to the other extension of PI cover provided in the policy. Context of these provision insuring clause are, as stated earlier in the clause, damage as defined as physical loss, destruction or damage to any building or other property used in connection with insured business. The extensions concern different property, generally speaking, damage to other properties such as damage to expressive supplies of public utilities. More importantly, limits for the extension are expressed differently. There is no reference in clause 1 of extensions applicable to section 2 to an aggregate limit of indemnity. There's simply an unadorned reference to the limit of indemnity in the schedule. That's a reference to any of one occurrence limit, not an aggregate limit. The conclusion is supported by considering specific loss of attraction, and then he deals with the loss of attraction endorsement, and he effectively rejects the application of anything in that wording I've shown you in relation to section 2 to the prevention of access non-damage endorsement. And I think it's fair to say, and the other points, as one sees in what Mr. Kramer said at 242, and then at 243, he deals with some other arguments. He finds at 244 that there is an automatic reinstatement, and then the conclusion is at 246. I reject the argument that the POAND clause is subject to an aggregate limit. In my view, the relevant limit is any one occurrence as provided for in the limit of indemnity provision, and there is no aggregate limit. And we did try and appeal the point. We did try and appeal the limit point as to whether limit meant limit of indemnity. The judge refused us permission to appeal, as I think I may have mentioned yesterday.
Yeah.
And Lord Justice Mayles did not grant us permission to appeal. So I have to accept that the 1 million limit for prevention of access non-damage is a 1 million per occurrence limit. But that's the only limit there is. If I can put it that way.
Yes, can I ask you about that? How that?
Yeah.
Just working backwards from the POAND extension at page 140, the limit is expressed as the amount in the schedule. Yeah. And the amount shown against this extension in the schedule is a figure under the heading limit, and as you've explained to us, the judge has held, and that's no appeal from that, that limit means capital L limit of capital I indemnity as defined, and the reason that means any one occurrence is at page 72 in the definitions.
Yep.
We've got a definition of limit of indemnity. Am I right so far? Can we just look at that and see where that takes us? At page 72, limit of indemnity shall mean, for the purposes of sections 1 to 6, which is what we're concerned with, total liability of the company for all amounts payable in accordance with the capital I insuring clause under these sections for for any loss or serious losses arising from any one occurrence. So that's where you get the any one occurrence from, but it's the total liability of the insurer for all amounts payable in accordance with the insuring clause. Now, if one has to ask for what's meant by amounts under the insuring clause, we have to go, don't we, to the insuring clause under section 2 at page 81.
Yeah.
I don't think there's any other capital I, capital C insuring clause that could be relevant in this
That's right.
context. And that's where we find the wording we've been focusing on a moment ago, that under proviso 2, the liability of the company under this section shall not exceed the aggregate limit of indemnity, and you accept that is an aggregate per policy. That's a per policy limit, not a per assured limit. Now, I think the argument against you is that if one traces that through, once you accept that the limit in the POAND extension at page 140 is a capital L limit of capital I indemnity, and if a capital L limit of capital I indemnity is only used in this policy under section 2 to mean an aggregate limit per all assureds, see page 81, that must be the meaning that it's given at page 140. What's your answer to that way of putting it?
Well, my answer to that is that 140 doesn't actually use the term limit of indemnity. And effectively what 140 is, as I've said, effectively a contract between a particular insured and a particular and the insurer. And all one does is even one, if the limit of indemnity, if the term limit in the actual schedule has to mean limit of indemnity, then one works the figures, goes back to look at the aggregate limit of indemnity. The aggregate limit of indemnity is the 89 million figure. So it says it should not exceed 89 million. But the 1 million figure, which one finds in the schedule, is a 1 million per contract. And what the judge found is that there wasn't an annual aggregate. What he found is that it was a 1 million limit of indemnity, a 1 million per occurrence limit per contract, which in my respective submission is the right construction. If one accepts that limit, which I have to, means limit of indemnity. But the fact that what one finds in the wording at page 81, which said the liability of the company under this section shall not exceed the aggregate limit of indemnity as stated in the schedule. That's the only provision which effectively limits the amount payable, and that refers to an aggregate limit of indemnity as stated in the schedule. In my respective submission, the aggregate limit of indemnity stated in the schedule is the 89 million figure.
So is the short point,
sorry, the 106 million, sorry.
so is the short point that even if you read page 140 as referring back to limits, meaning capital L limits of capital I indemnity, there are recognised at 72 and 81 capital L limits of capital I indemnity, which may not be the same in each case. What is referred to at 81 is identified as an aggregate
Yes.
capital L limit of capital I indemnity, which is obviously apposite to the top half of page
Yeah.
56. But just because the bottom half of 56 is also a capital L limit of capital I indemnity, doesn't mean that by reference to page 72, that also is
Exactly.
aggregate. Because you don't there have the aggregate wording, and the question which arises in relation to the definition at page 72 is whether the total liability of the company is a reference to the total liability of the company under the policy as a whole, or the total liability of the company to the particular assured, which you say, when you go back to the POAND clause, can only be the assured because of the nature of the insured, the premises, the danger, and so on. Is that how you put it?
Yes, I mean, if one looks at section 2 again, which one then 81, one sees the reference there to the liability company under this section shall not exceed the aggregate limit of indemnity as stated in the schedule. Well, what is the aggregate limit of indemnity? One goes back to page 56 and one sees in those circumstances a figure of 109 million, which is the aggregate of the figures. The 106 million is the aggregate of the figures of 1 to 9, and that then says total business interruption. That is the aggregate, because you effectively are adding up the various figures in 1 to 9. So effectively, it's a provision which says that the liability of the company shall not exceed 106 million. So even if one was talking about the aggregate of all the claims from the POAND clause, it would have a cap of 106 million. But there is nothing in my respective submission to say that, for example, the prevention of access non-damage 1 million is an aggregate. It's not an aggregate of anything. It's not said to be an aggregate. And if one looks at 140, 140 in my submission makes it quite clear that one has got effectively, this is a benefit given to a particular insured, and then it says the wording in 140 is provided the company shall not be liable under the extension for more than the amount shown against this extension in the schedule. And that is a provision in the particular contract between the insurer and the particular insured. So if one looks at 140, it effectively says the company shall not be liable under this extension for more than 1 million to this particular insured. It's not 1 million in the aggregate or anything.
Well, the point is that the amount shown in the schedule is a capital L limit, which it's been held means a capital L limit of capital I indemnity, which is a defined term, and it's defined at page 72, not page 81, but it's defined at page 72. And I understand what you say about aggregate, but at 72, it's defined as a total liability of the insuring company for all amounts payable in accordance with the insuring clause under these sections for any loss or series of losses arising from any one occurrence. Is that not aggregation wording?
No, it's one occurrence wording, but of course this is a provision in a particular contract between a particular insured. Because effectively, this is a provision in 20 separate contracts. So effectively, total liability company for all amounts payable in accordance with insuring clause under these, insuring clause under a particular contract. For any loss or serious loss arising from one occurrence as stated in the schedule. So it is effectively 1 million, as the judge found, per occurrence, but 1 million per occurrence in each contract.
Thank you.
Right. Can, I mean, if
You
this
have to, I mean, the judge, I think I'm right in saying, I was trying to find out where, because the problem is the judge dealt with a lot of this in the context of the Gatwick policy, where you also represented the Gatwick claimants, who were only, I think, appealing furlough. They're not, there's no appeal against them by the insurers here. But I think what the judge found the limit in relation to the POAND cover, limit of indemnity. But on the basis that the limit of indemnity definition, I put it that way, was applicable to the individual insured. Although, as my lord, I think is pointing out, that the wording is on that basis slightly obscurely drafted, but we have to take it. That's what the judge has decided.
If, for example, the definition of the limit of indemnity, which one had at page 72, has said, irrespective of the number of insureds insured under this policy, then that might be a different situation. What it does here is effectively the wording, the actual, that this is effectively the standard form, is drafted on the basis that there is actually one insured. And when one actually, in my respect for submission, translates or applies this to a particular company who's insured under a composite policy, you apply that to that particular company. And then one looks at 140, which we have looked at. And in my respectful submission, one then gets to a position where the 1 million limit applies per occurrence to each particular company. That's my submission.
Yes. In other words, even assuming that the POAND clause incorporates the limit of indemnity definition at page 72, that is a definition which doesn't have aggregate wording, but is a limit per assured.
Yes, it's a limit per assured, because what one is applying the wording in a sense in relation to 20 separate contracts.
Well, of course, Gatwick was
Yes.
6 separate contracts, so
Yes.
the judge didn't have to grapple with this point at all. I was just looking at the bit of his judgment that deals with this. He doesn't actually. Was it argued by the insurers below the effect of deciding the limits meant limit of indemnity must necessarily mean that the limit in that conclusion necessarily led to the conclusion that the POAND cover at page 140 was an aggregate limit. Because there's nothing in the actual wording that suggests it's an aggregate limit at all.
No, and if I can take you back to the judge's judgment at page 54, of the core bundle, which I don't. I mean, effectively, this is a point I won on. There isn't, in fact, an appeal on this point from the other side. But if one goes to 246, I reject the argument that the POAND clause is subject to an aggregate limit.
Sorry, which page are we on?
It's page 54 of the joint core bundle.
Yeah.
I reject the argument that POAND clause is subject to an aggregate limit. In my view, the relevant limit is any one occurrence provided from the limit indemnity, and there is no aggregate limit. In reaching the conclusion that reasonable reading of the policy would not conclude that the POAND cover was subject to an annual aggregate, I derive some comfort that the insurers have been inconsistent in their pleading various cases as to the existence or basis of an annual aggregate. Thus, while Liberty Mutual was pleading and Fuller's advanced a case of annual aggregate pleading, and then he effectively he then effectively finds against the insurers at this point. So, in my respectful submission, he finds, I think, in relation to Starboard, that Starboard's, so he.
But that's all in the context of a distinction between aggregate and any one occurrence. Aggregate meaning for each individual assured in Gatwick. It wasn't looking at aggregate for the policy as a whole, as a concept. So none of that is really on the point that we're on for Starboard. It's just when he gets to Starboard.
Yeah, at 279 at page 59.
Yes.
He says, in the light of my earlier conclusion, I answer issue 13. In Starboard, does the limit of 1 million with an indemnity period of 3 months apply separately respect of each individual contract?
Yeah.
Yes. And or separately each, I don't know, separately, so the limit of 1 million applies in respect of any one loss or series of losses arising from any one occurrence. The question of how many occurrences there were is reserved for later determination. So he finds that the limit applies per company.
Yeah. So the overall effect of 279 is this decision. The limit is a per insured limit.
Yes.
But for each insured, it's applies in respect of any loss or series of losses arising from any one account.
Yes, exactly.
Full stop.
Yeah. And unless I can assist you further, those are my submissions.
If I may, start with the issue of expectation, and what Mr. Kramer seeks to relabel as a per-insured point, but the composite policy point. Now, today Mr. Kramer reverted back to this being some form of presumption. Yesterday, transcript page 175, he disavowed it being any presumption, nor a maxim, nor a canon of construction, nor a matter of law, nor a matter of fact. One asks rhetorically, what, pray tell, is it? With respect, we would agree with my Lord Justice Phillips that when one is looking at the issue of construction and how one construes this policy, and I'll come back to that point in a moment, the policy, one obviously needs to bear in mind that there's more than one insured involved. That's not a presumption, to be fair, it's something that should be obvious on the face of the document. However, it was said with exchanges from the bench yesterday, and repeated to some extent today, that this involves recognising that there were separate contracts with separate rights. And again, Mr. Gruder said a moment ago about page 140, that one treats that extension as if there were 20 extensions. I don't agree, in my submission, that's wrong. One starts with the proposition there is but one policy that contains within it individual insurances with the policyholders, but they are not hermetically sealed and freestanding. They are related and that may have implications in terms of placement, presentation, avoidance. They may also be expressly related in terms of the limits. Because it may be that a claim by one does diminish indeed the pot available to another. I'm going to come on to that point in a moment. So,
Just to cut, we don't, as a matter of law, we don't construe or interpret policies. We construe or interpret contracts. I think outside the concept of a policy being a contract, I'm not sure what a policy is, other than a document.
well, I stress that point simply in terms of the Marine Insurance Act. One has to have a policy. There may be separate contracts if different insurers subscribe, i.e. with the quota share insurers, it's still one policy. The point is that there may be contracts within that, but what are the terms of those? And are they only relevant vis-a-vis the individual? Answer no, because as one saw from Technip, there may be the provisions in the policy which are taken as a whole in respect of all the parties to that policy who have individual insurances.
Yeah, because there may be a provision in the policy which makes it clear that that particular provision applies to all insurances comprised within the composite policy.
Or it may be implicit, my lord, as one sees in Bath Racecourse with the figures given for the limits of property damage. Not expressed anywhere that's an aggregate limit, but it's blindingly obvious. But the point there is that one can never say that I look at that policy and I treat it as transposed and the only party to it is the insurer and that policyholder. One doesn't look at it in that silo. One looks at it as a policy which has given rise to insurances to which there are 20 insureds, and one may then have to query what is the implications on their rights and what do the exercise of their rights in the past mean to the the validity of the current claim. So that's what I'm pushing back against, the idea that one treats these as entirely separate and individual. In my submission, that is
Well,
not.
it can't be right, can it? Because as you just pointed out a moment ago, the aggregate limits, the 89 million or 66 million or 106 million, whichever contract we're looking at, plainly is something that is referable to the whole, to all of the insurers taken together
Yes.
as an overall aggregate limit.
Yes.
So there will be provisions, whether you look at it in terms of provisions of the policy or provisions of each individual contract, there are going to be provisions within each individual contract that actually, in your example, impose limits which derive from the totality of the insured, not just this insured.
Yes.
And the question that we have really comes down to a pretty short one, doesn't it? Which is whether the limits that we're looking at, the limits that are applicable just to this insured, whichever this insured is, or overall aggregate limits.
Oh, yes.
That's what it is.
One does that by construing it within the proper context. And part of this debate between the parties is to what extent one gains any assistance at all from any expectation or a view that in general there will be multiple limits. And I to be clear, I do not accept the formulation that in general there will be multiple limits, because one takes a composite policy and that is going to ensure separate interests. Now those separate interests in these current cases before you are very closely related, indeed intimately so, and financially and functionally they may be equivalent to a single policyholder. But one can have, for example, Huller Machinery, interests which are completely separate. And one may say, well, depending on what the composite nature is, because it could be in any sector, for any risk, those are bundled up into this policy. Next question, well, what's covered by that? And in respect to that cover, what is the limit?
Why when you say they're instantly connected, how does that work? Because whether we're looking at racecourses and golf clubs and so forth, or we're looking at hotels, each insured has its own premises or its own business,
Yes.
separate from all the other businesses,
Yes.
and at a different location. and the danger, the COVID danger, was not necessarily the same at each location for the reason that I discussed with Mr. Gruder.
No,
So what's the intimate connection other than the fact they're associated companies which happen to run racecourses or hotels?
I'm going to come on to the connection in terms of the diminishment of the pot. But I'll deal with that point now, because it was relevant to what was said yesterday, that it would be unfair that one has the occurrence of an insured peril to policyholder 1, and that diminishes it to policyholder 2. With respect, that's not unfair. That all depends on what the policy says, namely whether what has been granted by it is an extension which grants a pot of a certain amount available to all or to each individually. And if it is to all, then of course claim by party 1 is going to diminish what's left to party 2. Now, to the extent one wishes in the abstract to complain of potential unfairness, for example, that there's been losses in January and February, and one's rather concerned that that has eroded the available cover for the rest of the year, and one's slightly nervous about some reoccurrence of a problem later, that can be dealt with. A competent broker would say, make sure there's a reinstatement. Might have to pay for it, but that can be topped up. And that one shouldn't ignore the usual well-known system whereby when that sort of limit is provided, it can be, as it were, refreshed.
Yeah, but
for
the
a fee.
difficulty with that argument, I mean, I follow that point. The difficulty is that when one's looking at issues of reduction of limits through reinstatement, reduction of limit and then reinstatement, is normally in relation to the insured, not in relation to some other insured who happens to be, coincidentally for convenience, insured under the same policy.
If your lordship is saying that one can't have reinstatements in the composite policy,
No, I'm not saying that at all. I'm simply making the point that normally what reduces the indemnity
yes,
is a claim by the insured, not a claim by a separate insured.
in my submission, my lord, the source of that complaint is predicated upon the idea one is in the silo with the individual claims and interests, and I'm not accepting that, and one shouldn't accept it on the facts of this case either, and I'm going to come on to that in a moment. So if one's dealing with...
Leave aside silos. I'm just having a little difficulty myself in what fundamentally is the objection to characterising a composite policy as being, as a matter of law, a series of separate contracts of insurance on the terms of the policy between each assured and each insurer. They are separate contracts of insurance, aren't they?
Yes,
Juridically.
yes.
And is it therefore the case that, as my lord says, one is, as a matter of construction, seeking the meaning of the particular contract of insurance on which the assured we are concerned with and the insurer with which we are concerned
Yes,
was party to?
in the context.
If there were only, if there were only a claim by one of the arena
Yes,
companies, we'd be looking at that.
oh yes, but that would still be in the context of, ex hypothesi, a single contract that is part of a bundle of other contracts, and that may have consequences.
It's a bundle. It's a bundle of contracts, and so, for example, although juridically there might be a different factual matrix as between one assured and another.
Yes,
Nevertheless, if one were looking at a term which was a term which applied to all of them in the policy, you might say, well, you start with a presumption as a canon of construction that it must mean the same for everybody, even if their individual circumstances might be slightly different. So, of course, I'm not saying that you ignore the fact that you have a single policy, but there seemed to be a reluctance to accept that juridically it's a series of separate contracts of insurance, but you do accept that.
no, I do, my lord. And forgive me if I've given that incorrect impression. I suspect that is because of the keenness of with which I'm trying to stress upon the court the idea that this is maybe a separate contract, but is not in the silo. It is not wholly independent because, first of all, the matrix is different. It needs to be construed as part of the suite of a bundle of contracts. And importantly, one is not looking, when one construes it, in isolation to that claim of that insured, because the implications of the available limits, for example, of that insured may be affected by what has transpired under the separate contracts of other policyholders.
This is nothing particularly remarkable about that type of situation. One often has suites of documents in, for example, complex loan transactions where you have a number of contracts between different parties, but you construe them all together.
Right.
Because they're all signed at the same time, and they inter-refer to deeds with trustees or with guarantors or whatever. You look at them, you construe them all together, but they are separate contracts.
Oh, yes.
And you construe each contract, but in that context, and there's nothing decisively controversial about that.
There is nothing exciting or controversial, but if one transposes that a lack of excitement to the insurance context, it doesn't give rise to any expectation of what will happen in general. My only point is it all depends on what is being done.
I don't think that's what it comes down to. It's not an expectation, it's simply the fact that the starting point for when you look at the position between insurer A and insured X is that the provisions relate to their relationship, and that's the starting point. You then construe that in the context that that same provision relates to all of the insured in their separate contracts, but the starting point is you are looking at that one contract and another contract and another contract, and I don't think there's very much more to it than that.
If I can give an example, my lords, it was said in questions from the bench that in general one would expect each policyholder to have their own limits. Now just take a simple example of a property damage, first party property damage cover that is on a composite basis. So there are multiple insureds with, on that premise, multiple properties. Would one say in general that the limit would be an individual limit for each insured? The answer is no, because it would depend on whether that is a portfolio cover or whether it's a scheduled policy. That's the first question one would ask. The first question always asked for the property cover, is it scheduled or portfolio? And therefore one has to know what the parties have done. That's my only point. It all depends upon the structure. There's no in general, it's merely a matter of what was agreed. So when one moves to extensions, it's a matter of if I've extended it in a certain way, is that to everybody, or has the add-on a limit which applies to everybody? So when one then looks at the schedule here, and one looks at page 54 of the Liberty policy, and one sees the absence of any reference to the phrase in the aggregate, but one knows that this is a composite policy, and the factual matrix, one knows how those figures have been put together, and one looks at the limits. Would a reasonable policyholder think in general those applied individually to each? The immediate answer would be my submission, no, of course not. They're in the aggregate. It doesn't say that, but it's common ground, they're in the aggregate.
So which limits are in the aggregate?
If one looks, my lord, at page 54 of the Starboard bundle,
Yeah.
item 1, buildings.
Yeah,
That's
in
the
the
aggregate.
aggregate. Because it's 166 million.
But, my lord, yes, but there's my point there is...
Because there were declared values. I mean, we don't have all the documents. That's part of the problem with these arguments these last 2 days. There were clearly declared values for each premises in
Yes.
this policy, at least.
Yes.
This is Starboard. I don't know if there were for Bath Racecourse as well. I suspect there were, because I think it also refers to.
Yes, there were, but again, not on a schedule basis. It was on a composite.
No, but
cumulative.
there were declared values for
Yes. Yes.
each premises or each racecourse
Yes.
or whatever. So the declared value from which you could see from a schedule, not a schedule in a policy, but just a document, you could see that there were declared values for each premises,
Yes.
say 10 million or 15 million or whatever, adding up to 144 million.
Yes.
And therefore, as a matter of construction of this, these provisions clearly are, the top half of the page is clearly on an aggregate basis, and the question for us is whether the bottom half of the page is on an aggregate basis as well.
At one level of analysis, your lordship's right, but just pausing for a moment, one shouldn't forget that although those figures are provided on a scheduled basis, I want to correct the point made yesterday by Mr. Kramer, the declared values do not operate to limit the claim by any particular party. The limit of one policyholder who has a claim is potentially, one sees on page 54, 190 odd million. Now that's very unlikely, given that that's a cumulative total.
No, I follow that point.
So that's the aggregate limit, but and that may be right for buildings, and one may say, well, that's all very easy. And one may then quickly gloss over the machinery and plant. Query stock, is that going to be aggregate? Debris removals included. Wine and spirits, is that individual or in the aggregate? In my submission, that would be in the aggregate, because those are the limits, and that's listed. One would think, well, I'm running down here, I'm the reasonable policyholder, that's the total across the board for these various people. That's their stock. One sees a not dissimilar amount in the path. And then if that's right, that all those figures, and this is common ground, 1 to 10, are all in the aggregate, it's supposed to be obvious to the reasonable policyholder there's a paradigm shift once one goes below that. And then the same points can be made at page 56. Because I should know that, of course, there are inner limits on page 54, and that might put somebody on notice. But there's no distinction drawn between the limits on page 56, because there one again looks at the top of the page, and they are in the aggregate. And that would include the item 7, outstanding debit bans, etc. And once I've worked through this as a reasonable policyholder and assumed quite rightly that those are aggregate limits, one asks, well, when I look then beyond that, why should the limit, which means limit of indemnity, the same as the top half of the page, mean something different? What is the flashing lights there that put me on notice that's actually no longer on a composite and aggregate basis, but something else?
Do you have any submission on extension 60, loss of attraction?
Exception, sorry, I didn't quite catch the last bit.
On page 57, extension 16 is loss of attraction, which the limit is 5 million.
Yes.
About that.
Well, it was, I do, and if I can, bear me 1 second, I can make the point quickly. It was made by Mr. Gruder that loss of attraction, that these extensions are somewhat arbitrary, and therefore they're just as it were plucked out of thin air and apply to everybody because they're rather modest. But one sees here on loss of attraction, that's 5 million. That's a healthy figure. This is a composite policy. Now, just to make good the point that, or rather to undermine Mr. Gruder's point, these aren't arbitrary. If one looks at a policy which is on with 1 insured, one has loss of attraction. It's in the Gatwick policy. It's 500,000. So what one sees, and I can only take this so far, is that when one has a much larger figure on a composite basis, the reasonable policyholder may be thinking, well, that's because it applies to everybody.
Loss of attraction extension is for loss of revenue, isn't it?
Yes.
I just wondered
1 to
whether
8.
there's any significance in the fact that if you multiply that by 20, you get roughly to the total limit of indemnity.
My Lord, my submission, no, in the sense that all the extensions, all concerned with loss of revenue. So one is always dealing with that measure of loss. That's all we're ever dealing with under section 2. But if what your lordship's saying is that there's some doomsday scenario whereby the loss of attraction,
I don't think, I'm not sure this works with respect, because the loss of attraction cover is expressly an any one occurrence cover. So it's I don't see how it can be 5 million in the aggregate on that basis.
no, per occurrence. But on this basis, if there is an occurrence whereby there is a loss of attraction because
Yeah, but let's take an example. There's a huge fire in the city centre, as a result of which people don't go into any of the people don't go into the city centre because they're scared of what has happened or whatever. So there's a loss of attraction for the premises within a 1 mile
Yes.
radius, which is what's about. So they're the insured of the relevant. If we're looking at Starboard here, the insured for the relevant hotel says, well, our hotel ceased to be as attractive as it was, and we've lost 3 million.
yes,
So they've got a claim for any one occurrence there of £3 million, right? When along comes claim number 2, where there's been a, I don't know, rats in the nearby building,
Yes.
which is one that
separate
was talked
occurrence.
about quite a bit in the test case. Rats in the nearby building, in a completely different city, completely different insured. That insured has the loss of attraction claim for 3 million. Comes along to make a claim under page 128. And on your argument, they're met by an argument by the insurers arguing there's only 3 million left of the cover.
That's not my argument, my lord. I am bound by below that this is the limit per occurrence. My point is that in your lordship's example posits 2 different occurrences. There are 2 limits. If one changes the example whereby there's an outbreak in the northwest of Foot and Mouth,
Yeah.
and that is the same occurrence that cuts off all the hotels in that area.
But the effect of the judge's judgment on a point that's not appealed is to write in the words for any one occurrence into page 140, isn't it? Right, the company shall not be liable under this extension for any more than the amount shown against the
Yes.
extension in the schedule
Yes.
for any one occurrence.
Only one occurrence. But because it's composite, I say that's any one occurrence, and if the same occurrence causes multiple losses, that same occurrence to multiple policyholders giving rise to multiple claims, that's one limit. Mr. Gruder says no, because it's composite, one looks at it within the silo, blinkered to that policyholder, and if there's one occurrence, or they're causing damage to multiple insureds, there is one limit for that one occurrence for that one policyholder, and that's where in my submission the learned judge went wrong. I'm more than happy to
The
accept.
judge wasn't dealing with the issue as to whether or not there was one occurrence for the purposes of all the claims, was he? I mean, that argument is predicated upon the idea that the 21st of March regulations is one occurrence for everybody. Is that right?
Whose argument, my lord?
Your argument just then
Yes.
is predicated upon the fact there is only one, well, never mind how many occurrences there are, but let's just say that there's one occurrence, which is the 21st of March regulations calling for the shutdown of the businesses.
Yes.
And all the insured's claims arise from one occurrence. That one occurrence, that's your case, isn't it?
To be, the other side, Mr. Gruder's only pleaded 2 occurrences.
Right. I follow that, but you're saying they've all the insureds claims are aggregated into one £1 million limit for that one occurrence.
Yes.
Yeah, I follow.
Sorry if I made heavy weather of that.
Well, one of the problems, and I'm not being critical at all, but one of the problems we face is that we've actually only got, as it were, half the picture, because there are all sorts of issues that are still yet to be decided between these parties, which is no doubt why these parties haven't settled, unlike everybody else. But and there's going to be a trial in May. It kept on telling us, and we don't know exactly what's going to be tried. We have a pretty good idea.
I may have made some of those.
It may be that it comes back to the problem of having preliminary issues which don't actually cover all the construction issues that arise, because reality is that there are a number of issues which do arise, which it might have been, in retrospect, more sensible to have decided at the same time as these issues.
I may have made those points, my lord, in resisting the application for preliminary issues. Anyway, we are where we are.
Right.
To the extent I need to, on the commerciality of the pot being diminished, and policyholder 1 not knowing, claim later in the year not knowing the pot's been diminished, that's just the incidence of an aggregate limit. But on the facts of this case, I want to be quite clear. Your lordship, the Chancellor asked yesterday, are there common directorships? Mr. Kramer said quite rightly that that's not in evidence before you. It will be in May. That may or may not show just how very intimate they are. But what the facts and the assumed facts do show is that whilst each, within Bath Racecourse, each venue may have a different day-to-day manager on the ground, they all report directly across the country. They all report directly into the managing director of racing, who then sits within the senior leadership team of Arena, as that topco, as it were. And that's paragraph 30 of the facts at page 152. So the idea that these are all disparate entities not knowing what's going on the facts as we know it, is simply not correct at all. I've made my point already about a concern if the limit is being diminished because claims are rising. There's a reinstatement, pay extra premium. Both policies have reinstatement provisions. The policyholders never sought to activate them or pay extra premium. So the pot's dwindled, the pot has dwindled. In terms of the cases that you were shown to, in terms of the words aggregate, you had my point that seeing that word in a policy does not, although its absence does not mean that those are not aggregate limits. One sees that from both the schedules where it's absent but it's agreed. But of course that is the most common use of an absolute limit. But even when one sees it here for greens, Mr. Kramer still won't accept that actually. And one has to ask, well, how on earth could it be so? And you're asked to assume that there can't be an aggregate because nobody is concerned about £20,000 on pesticides and golf greens. With greatest respect, anybody who's been through the Umbrellas litigation can't make any assumption about potential liability for pesticides. So that's an equally, in my submission, poor point. You may recall yesterday, Mr. Kramer just about made a point on the premium and the difference between Starboard and Bath. And I just want to correct what was said because the figures that Mr. Kramer gave were not quite right. It's fair to say he didn't push it excessively. But what he meant to say was that, what he did say, forgive me, is that Starboard only paid 80,000, whereas Bath Racecourse paid 560 odd, and therefore great difference, and there must be implications flowing from that in terms of the multiple limits. Well, it's not comparing apples and pears there. The limits, the premium in Bath were for all sections bar terrorism. If one looks at the premium in Starboard for all sections bar terrorism, it is £180,000. And whilst the BI cover is roughly the same for both, the property cover is 166 million for Starboard, and yet nearly 600 million for Bath. So all one sees is a higher premium, because there is indeed a higher risk being taken for more cover. So we can take nothing from that.
I'm not sure one gets anything from the premium figures, really.
No.
Whoever's right or wrong on the point.
But yes, but I want the court to be clear what the figures are. Unless I can assist further.
Thank you very much, Mr. Scoy. Right. Well, we thank all the parties for their extremely interesting and helpful submissions so far. We're obviously going to reserve judgment. The intention is that we produce one judgment in respect of both sets of appeals. So I won't say anything more about when you might get a draft judgment until we've heard the appeals next Tuesday and Wednesday. I've already made the grass, and I'm sorry if the court have been, or if I've been slightly ill-tempered on the subject, but I've made the point about the bundles for next week. Please do sort out something more sensible than what we had these 2 days. I'm afraid you will have to clear the court, because the court needs to be used for other purposes tomorrow. And since you're not here till Tuesday, I don't know whether it's needed on Friday or Monday, but you will have to clear out and start again next week. But thank you all very much.
My lord, can I just address the bundles? We're a bit nervous about getting it wrong again.
Yes.
So we've got our furlough appeal authorities bundles. They can presumably stay as they are.
Further, if the only cases you're going to refer to next week
They are
are
not,
already in the bundles.
No. So
Attention, please. We are investigating an alarm in another part of the building. Please listen for further announcements.
This may be a fire drill. But
So,
whether
my
it
lord,
is
one
or not-
proposal. There are these common bundles. The thought
Yes.
being that they are also relevant to furlough as well as limits.
Yeah.
We could just renumber those as furlough 4, 5, and 6, and then there will be one or two others to bring across from the insurer appeal bundles. But it really
The
depends.
joint bundles are not composite. They're not a combination of the.
They're supposed to be cases relevant to both.
They're supposed to be both, but they're not. Is that what you're
Well,
saying?
no, they are, but we've done this one now.
Well,
So
they're composite
Well,
bundles rather than
if
joint
the
bundles,
joint
aren't they?
authorities have everything in them,
no,
people want to refer to.
they absolutely don't.
What sense
Well,
are they
the-
joint?
The joint, they're all joint. Joint doesn't.
It's
Joint
very
means the
simple.
two
It's
appeals.
incredibly simple.
Yes, I know, my
The
lord.
bundles we have for next week, all the authorities that we need
Yes.
should be in one set of bundles. Now,
Yeah.
whether you use these bundles or have to produce other
Yes.
ones is up to you.
So my
But what we don't want is a whole load of authorities that we've,
No, we don't want.
for example, we're not going to deal with. Likewise with the documents. Now, we obviously need
Yes.
policy documents. I put them into a separate bundle. But anything else that we need should go into the furlough bundles.
I think my real question is, to what extent should we be worried that you've already marked some of these authorities up and need to keep them, or
Well, we're
should
going
we
to
just
keep the
provide
bundles
you with?
anyway.
Should we just, but from this week to next week, or are you happy to be
No, we're
provided?
going to keep our bundles
Yes.
in any event.
Yes.
You'll need
Yeah.
to send somebody to
Yeah.
add to them. That's what I'm thinking. I'm not suggesting you rip them all up and start again. I'm suggesting you add it to them so we had all the authorities in whatever we need for next week in the furlough appeals.
I think I have what we need. Thank you.
So one set without duplication within that set.
Yes.
Yes, happy with that. Not let's all put them all together and there are
No,
five
no.
different copies of
No,
a
that doesn't
particular.
help you carry them backwards or forwards.
authority.
I understand that.
All right. Thank you very much.
Court rise in favour.